Thank you for visiting the Miltenberger Law Offices YouTube channel and our website. We are a proven criminal defense law firm in Nebraska, with over 1,000 cases handled and over 12 years of combined legal experience. Our firm has created these audio articles to help educate you on your rights, protect your freedom, and help you achieve the best solution for the charges you are facing. If we are hired for your case, we will never back down, no matter the odds. Theft Lawyer, Omaha, Nebraska. A theft charge in Omaha, Nebraska can come from a store, workplace, shared home, borrowed vehicle, online transaction, or business agreement. Sometimes police believe the case is straightforward because property was found in someone's possession or money changed hands. Often, the full story isn't that simple. You may have believed you had permission to take or use the property. You may not have known an item was stolen. A missed payment or disagreement over ownership may be treated as a crime even though it began as a civil dispute. In some cases, the state may have the wrong person, or may be using an inflated property value to turn a misdemeanor into a felony. Nebraska theft charges can carry anything from a fine to as many as 20 years in prison. Before giving Omaha police an explanation or accepting the value listed in the report, speak with an attorney who can protect your rights and hold the state to its burden of proof. Miltenberger Law Offices is Omaha, Nebraska criminal defense lawyers defend people accused of misdemeanor and felony theft throughout Omaha and Nebraska. Call 402-217-2267 or contact the firm online for a free, confidential consultation. Theft crimes in Nebraska. Nebraska handles theft differently from many other states. Instead of having several different laws for different types of theft crimes, under Nebraska Revised Statute Section 28-510, crimes traditionally known as larceny, embezzlement, false pretenses, extortion, blackmail, fraudulent conversion, and receiving stolen property are consolidated into the single offense of theft. The specifics of your case still matter. Shoplifting merchandise, keeping money entrusted to you, using deception to obtain property, and possessing something you believe was stolen involve different allegations and potential defenses. Nebraska law simply allows each of those situations to be prosecuted as a form of theft. Prosecutors do not always have to prove theft happened exactly the way it was first described in the charge. If the evidence supports another type of theft, they may still try to use it to secure a conviction. That means the defense must focus on the full set of facts, not just the name of the charge. Common theft charges in Omaha. Taking, keeping, or receiving property. Theft by unlawful taking. Taking, keeping, or controlling someone else's property with the intent to keep it from the owner. This can include money, merchandise, equipment, rented property, or a motor vehicle. Shoplifting. Taking or concealing merchandise without paying, switching price tags, placing merchandise in another container, intentionally underscanning an item, or bypassing a store security device. Receiving stolen property. Accepting, keeping, selling, or getting rid of property while knowing or believing it was stolen. Simply possessing stolen property does not automatically prove that you knew where it came from. Keeping lost or mistakenly delivered property. Keeping property after realizing it was lost, delivered to the wrong person, or received because of another mistake, without making a reasonable effort to return it. Embezzlement, deception, and theft of services. Embezzlement or employee theft. Keeping, transferring, or using money or property that was entrusted to you through a job, business, organization, or position of responsibility. These cases may involve cash deposits, company cards, inventory, client funds, or business accounts. Theft by deception, obtaining money or property by intentionally misleading someone, hiding important information, or allowing the person to continue believing something you know is false. Theft of services, receiving services while using deception, threats, fake payment, or another method intended to avoid paying. The charge may involve hotels, restaurants, professional work, transportation, utilities, or rented property. Theft by extortion, obtaining money, property, or something else of value through certain threats involving physical harm, criminal accusations, damaging information, business interference, or misuse of official power. A failed business deal, unpaid debt, accounting problem, or broken promise is not automatically theft. The prosecution must prove that the accused acted with criminal intent rather than making a mistake, falling behind on a payment, or becoming involved in a genuine financial dispute. Vehicle and rental property cases. Nebraska does not use grand theft auto as the formal name of a criminal offense. Taking a car, truck, motorcycle, or other vehicle with the intent to keep it from the owner can be charged as theft by unlawful taking. The seriousness of the charge generally depends on the vehicle's value. Other vehicle and rental property allegations may include possession of a stolen vehicle, receiving, driving, storing, selling, or disposing of a vehicle while knowing or believing it was stolen. Unauthorized vehicle use, using someone else's vehicle without permission, but without necessarily intending to keep it permanently. This is sometimes called joyriding. Failure to return rented property, keeping a rented or leased vehicle or other property beyond the agreed return date under circumstances that prosecutors believe show an intent to keep it. Prior permission, text messages, rental agreements, payment records, return notices, mechanical problems, and the reason the property was not returned may all be important. A late return or disagreement over permission is not necessarily the same as intentionally stealing a vehicle. Nebraska crimes related to theft. Some offenses involve stolen property or financial gain but remain separate crimes under Nebraska law. These charges may be filed alongside theft or instead of it. Identity theft. Using or possessing another person's identifying information without consent for an unlawful purpose, financial benefit, employment, or to cause a loss. Burglary. Forcibly entering property with the intent to steal or commit another felony. The state does not have to prove that anything was successfully taken. Robbery. Taking property from another person through force, violence, or fear. Because robbery involves danger or intimidation directed at a person, it is punished separately from ordinary theft. Possession of burglar's tools. Possessing a tool, key, device, or other item with the intent to use it, or knowing someone else intends to use it to forcibly enter property or physically take something. Organized retail crime. Stealing or possessing retail merchandise as part of a plan to resell or distribute it, helping another person carry out the scheme, or using tools or devices to defeat store security. Unauthorized use of a financial transaction device, using another person's credit card, debit card, account information, or similar payment device without permission, or with the intent to defraud. Nebraska theft charges and penalties based on value. For most offenses prosecuted under Nebraska's consolidated theft laws, the value of the property, money, or services involved determines whether the charge is a misdemeanor or felony. The state must prove that the property had value and establish the value range used to grade the offense beyond a reasonable doubt. Value involved: $5,000 or more. Charge level: Class 2 of felony. Potential. Sentence, up to 20 years in prison. Value involved, $1,500 to less than $5,000. Charge level, Class 4, felony. Potential sentence, up to 2 years in prison and 12 months of post-release supervision, a fine of up to $10,000 or both. Value involved, more than $500 but less than $1,500. Charge level, Class 1 misdemeanor. Potential sentence, up to 1 year in jail, a fine of up to $1,000 or both. Value involved, $500 or less. Charge level, Class 2 misdemeanor. Potential sentence, up to 6 months in jail, a fine of up to $1,000 or both. Other theft-related charges have their own penalty rules. Burglary, a Class 2. A felony carrying up to 20 years in prison. Robbery, a Class 2 felony carrying 1 to 50 years in prison. Possession of burglar's tools, a Class 4 felony carrying up to 2 years in prison and 12 months of post-release supervision. A fine of up to $10,000 or both. Identity theft. The charge ranges from a Class 2 misdemeanor to a Class 2A felony based on the amount gained or attempted. Prior identity theft convictions can increase the charge. Organized retail crime. A Class 1 misdemeanor when the total retail value is more than $500 but less than $1,500. A Class 4 felony when it is $1,500 to less than $5,000. And a Class 2A felony when it is $5,000 or more. Unauthorized vehicle use. A Class 3 misdemeanor for a first offense, a Class 1 misdemeanor for a second offense, and a Class 4 felony for a third or later offense. A conviction may also bring restitution, probation, court costs, and a criminal record that affects employment, housing, licensing, education, or immigration status. How prior theft convictions in Omaha, Nebraska, can increase the charge. Prior convictions can turn a relatively low-value allegation into a felony. A second or later conviction for theft involving more than $500 but less than $1,500 may be elevated from a Class 1 misdemeanor to a Class 4 felony. A second conviction for theft involving $500 or less may be elevated from a Class 2 misdemeanor to a Class 1 misdemeanor. A third or later conviction for theft involving $500 or less may be elevated to a Class 4 felony. For these enhancements to apply, the prior conviction must have occurred within 10 years of the date of the new alleged offense. Can Omaha prosecutors combine multiple alleged thefts? Yes. Nebraska law allows amounts taken from one or more people to be combined when prosecutors claim they were part of one scheme or course of conduct. That means several allegations that would each fall below the felony threshold may be grouped into one larger charge. For example, a series of workplace transactions, repeated retail accusations, or several transfers involving different people could be added together. How is the value of stolen property determined in Nebraska? The value written in a police report is not always accurate. Retail price may be relevant in a shoplifting case, but used, damaged, outdated, or depreciated property may be worth far less than its original purchase price. Depending on what was allegedly taken, the value of the item may depend on receipts and purchase records, the property's age and condition, current resale or fair market value, comparable online listings, depreciation, repair estimates, expert or owner testimony, the amount of money or services actually obtained. This is not just about paying less money in restitution. Lowering the alleged value from $5,000 to $4,999 can reduce a Class 2A felony to a Class 4 felony. Dropping it below $1,500 or $500 may reduce a felony to a misdemeanor. Possible defenses to theft charges in Omaha. Depending on the specifics of your case, your Omaha, Nebraska theft crimes lawyer may argue you had permission or a right to the property. Consent is a defense to theft by unlawful taking. Permission may be written, spoken, implied by past conduct, or disputed after a relationship or business arrangement falls apart. Shared ownership can also create questions about whether the accused knowingly interfered with another person's rights. You did not intend to steal. Borrowing, forgetting to pay, scanning an item incorrectly, failing to return rented property on time, or breaking a promise does not necessarily establish criminal intent. The state must prove more than carelessness or a failed agreement. You did not know the property was stolen. Receiving stolen property requires proof that you knew or believed the property was stolen. A low price or unusual transaction may raise suspicion, but the prosecution still has to prove what you actually knew or believed. The dispute is civil, not criminal. Some theft accusations grow out of unpaid debts, ownership disagreements, employment disputes, contracts, failed business deals, or breakups. A person should not be convicted of theft simply because another party believes money or property is owed. The value is overstated. Receipts, depreciation, condition, resale value, repair costs, and questions about the state's method of calculation can all be used to challenge the alleged value and potentially reduce the severity of the charge. The identification or evidence is unreliable. Store video may be blurry or incomplete. Several people may have had access to the property. Witnesses may make assumptions based on clothing, location, or association with someone else. Digital records and messages may also look very different when viewed in full context. The search was illegal. Police may recover allegedly stolen property from a home, vehicle, phone, bag, or shared space. If officers lacked a warrant, consent, probable cause, or another lawful basis for the search, an attorney may seek to suppress the evidence. What to do after a theft arrest? Do not try to explain everything to police. You may not know what witnesses said or what evidence officers have collected. Do not contact the alleged victim. Attempts to apologize, repay money, or return property may be misinterpreted. Preserve your records. Save receipts, messages, contracts, rental agreements, photographs, listings, payment records, and witness information. Do not sell, discard, alter, or hide disputed property. Let your attorney decide how it should be handled. Speak with an Omaha criminal defense lawyer immediately. Video can be erased, online listings can disappear, and memories become less reliable with time. How Miltenberger Law Offices can defend you against theft charges. Theft cases often turn on facts, specific facts. Who owned the property, whether permission had been given before, what the accused knew, and how the state arrived at its value. Miltenberger Law Offices can investigate those questions, preserve video and records, challenge illegal searches, examine witness statements, dispute inflated valuations, and identify gaps in the prosecution's theory. The firm prepares criminal cases with trial in mind, while also looking for opportunities to obtain dismissal, diversion, a reduced charge, or another favorable resolution. Cody Miltenberger began his legal career with the Douglas County Attorney's Office in 2010 and has more than 10 years of criminal trial experience. His background includes handling serious misdemeanor and felony cases and trying criminal charges before juries. Speak with an Omaha theft lawyer. A theft accusation alone does not establish that you intended to steal, knew property was stolen, or took something worth the amount claimed by the state. Those are issues that can be investigated and challenged. Miltenberger Law Offices represents clients facing shoplifting, felony theft, theft by deception, receiving stolen property, theft of services, vehicle-related allegations, and other theft charges throughout Omaha and Nebraska. Call 402-2172-267 or schedule a free confidential consultation with an Omaha theft lawyer today. Miltenberger Law Offices is a leading criminal defense law firm serving the entire state of Nebraska. We are headquartered in Omaha and serve Douglas County, Lancaster County, Lincoln, Sarpy County, and all of Nebraska. We look forward to helping you with your criminal defense attorney needs.